Welcome to the deep dive. Today, we're going to put on our court watcher hats and really analyze a stack of some pretty high stakes legal documents.
We are. It's all happening in a complex federal civil rights case. Meghann R. Miller versus the Kansas Department for Children and Families.
And this isn't about, watching a jury or a big trial. This is about the procedural battle that happens way before that, the fight that decides if a case even gets off the ground.
Exactly. The whole thing is centered in the U.S. District Court in Kansas. And back on November 20th, 2025, the court issued a memorandum and order.
Which was sort of a partial win for the defense, right?
It was. It dismissed the claims against the Maine state agency, DCF, and 2 of their employees.
But, and this is the key part, that same order came with a ticking clock for the plaintiff, Meghann Miller.
Right. She's appearing pro se.
Meaning she's representing herself, no lawyer.
Correct. And the court gave her what's called an order to show cause, or an OSC. She had until December 3rd to convince the judge, with a solid legal argument, why her remaining claims shouldn't also be dismissed.
So this is basically a screening process.
It is. It's required under federal law for cases like this. The court has to filter out claims that are frivolous or just not pled correctly. So for Miller, the mission was simple, but, incredibly hard. Prove your allegations are plausible enough to even get to the next stage.
And that was the mission. But, as you often see, procedure created the first crisis. We have 2 key filings from her, both dated December 6th.
Which is 3 days late.
3 days late. So one filing is all about why she missed that deadline. And the second one is the actual meat of it, the argument for why her constitutional claims are serious and need to move forward.
And that's our mission for this deep dive, to unpack the arguments she's using to try and save her case from getting thrown out on a technicality.
Because if she can't get over that first procedural hurdle, nothing else matters.
Nothing. The claims about parental rights, due process, fraud, no matter how compelling they might seem, they're just dead on arrival.
Yeah.
The court has to be convinced that the delay was justified.
So what's the legal term for that?
It's called excusable neglect.
Okay, so let's get into this procedural drama. She filed something called a motion for extension of time nunc pro tunc. That Latin phrase, what does that mean, basically?
It's a fancy way of asking the court to retroactively say the filing was on time, or to just accept it late, as if it were on time.
And what was her core reason for being 3 days late?
She calls it an honest calendaring mistake. As a self-represented litigant, she says she just misunderstood the order and wrote down the deadline as December 12th instead of December 3rd.
Just a simple clerical error.
That's the framing, yes. It's not about disrespecting the court, it's about a simple human mistake.
But the argument for excusable neglect, it's more than just saying, oops, my mistake, right? It has to be backed up.
Oh, absolutely. The filing connects that technical mistake directly to the trauma of the case itself. It's really powerful. The court already has documents about her disabilities, severe anxiety, PTSD, and the fact that she hasn't been able to work for over a year.
And this is where the filing gets very personal, but it feels strategically relevant.
It is. She talks about the ongoing trauma from being separated from her children, which has been going on for almost 2 years at this point.
Wow.
She mentions she's going through successive holidays without them, and she connects that stress directly to physical health problems.
What kind of health problems?
She says the stress is causing flare-ups of recurrent staph infections on her face, and that she had a flare-up right around when this deadline was due in early December.
So the argument is the very thing she is suing about, the separation from her kids, is causing the extreme stress that led to the simple calendaring mistake.
Precisely. It's a critical link. It changes it from a simple, I messed up, to a plea for leniency because she's actively battling serious health issues caused by the very actions in the lawsuit.
That's a really powerful argument.
It is. And she backs it up with an appeal to fairness. She points out the delay is minimal, only 3 days, and it doesn't harm the defendants at all. They didn't even have to respond to this.
But I think the smartest move she made was comparing her situation to the other side.
Oh, without a doubt. Miller points out that the court already granted the represented defendants, DCF, who have, state-funded lawyers, a comparable or greater relief.
What happened there?
They missed their deadline back in June by more than 2 weeks, and the court let them file a motion for an extension retroactively.
So she's saying if a team of experienced government lawyers gets a 2-week grace period,
then fairness would suggest that a self-represented litigant dealing with documented PTSD in a health crisis deserves a 3-day one.
It's a very compelling pitch for equity.
It really is. It frames a dismissal on this technicality as an especially harsh outcome. It's a very smart way to start.
Okay, so let's move past the procedural fight. Let's assume the judge says, all right, I'll accept the late filing.
Now we get to the substance.
Let's dive into the claims against the remaining defendants, starting with the Guardian ad litem, Randy McCalla. She's alleging he was personally involved in violating her constitutional rights.
He is absolutely central to the first big claims, which are about due process violations related to the removal of her children.
And the most explosive allegation here seems to center on that initial removal hearing back in January 2024.
It is. Miller alleges that McCalla went to the court for an ex parte emergency removal order. That means she wasn't there to defend herself.
But here's the pivot, right? This is the core of it.
This is the core. Miller alleges that McCalla was told before that hearing by the DCF investigator, Michelle Merritt, that the abuse allegations against her were unsubstantiated.
Wait, so he knew?
According to this filing, yes, he knew. And she claims he didn't disclose those exculpatory findings or her clean drug test to the judge.
And the result of him allegedly withholding that evidence was the no-contact order.
Which led directly to this 22-month separation. That alleged failure to disclose key exonerating information is the foundation for the due process claim.
It sounds like it goes beyond just a procedural mistake.
It does. It ties into what's called substantive due process, which is where the state's action is so awful it just shocks the conscience.
That's a high bar to clear.
A very high bar. It can't just be a legal error. It has to look like a conscious abuse of power. And alleging that a court-appointed officer knowingly hid facts to essentially sever a family that pushes it into that territory.
And this is where she has to provide enough facts to make the claim plausible, not just possible.
Right. You can't just say, my rights were violated. You have to show your work. And she does. She names the date, the defendant, the specific information she says was withheld, and the direct result.
Okay, let's shift to the First Amendment claim. This is about retaliation.
Yes, count 2. This is a classic protest and punishment scenario. Miller alleges she used her protected right to free speech, criticizing the custody case on social media.
And the punishment.
The alleged adverse action came from McCalla, who went to the state court in June 2024 to try and get an order restricting her social media activity.
But proving that he did that because she was criticizing him, that seems really hard to do before you can even get discovery.
It is. But she uses a couple of smart tools. First, temporal proximity. The timing is very close. But more importantly, she points to a later document.
What document?
DCF's official substantiation of emotional abuse against her from March of 2025. In that document, they explicitly cite her social media posts as the basis for their finding.
Oh, wow. So she's using the government's own written reasoning.
Who prove the retaliatory motive for McCalla's earlier attempts to silence her. It creates a very strong, plausible link.
That's a really sophisticated legal argument to make on your own.
It absolutely is.
Okay, so beyond the big constitutional claims, she also has state law torts. Let's start with fraud.
The fraud claim, count the 6, really just mirrors the due process claim. It argues McCalla presented a false narrative to the court by omitting those key exculpatory facts to get the removal order.
So same facts, different legal label.
Pretty much. Then you have abusive process, count the 7.
And how is that different?
This one isn't about starting a bogus case. It's about misusing a valid process, the custody proceedings, for an improper, ulterior purpose.
And that purpose, she alleges, was what?
To maintain control over the case and, ensure he kept getting paid his fees, even though he allegedly knew the evidence didn't support keeping the family separated indefinitely.
And finally, there's the claim for intentional infliction of emotional distress. I know that one is often hard to win.
Very hard. But she argues the facts here are different. The distress wasn't just caused by a mistake. It was allegedly inflicted by an officer of the court, the GAL, who was using his authority to intentionally sever the parent-child bond while hiding good news.
And she backs it up with specific harms.
Yes, very specific. Being forced to sell her home, huge costs for evaluations, and those stress-related health problems we talked about, the vision issues, the skin infections. She's arguing that a jury could look at all that and find the conduct atrocious and utterly intolerable.
Which is the legal standard you have to meet.
That's the standard.
All right, let's turn to the other defendants still in the case. The John Doe supervisors 1 through 5. These are DCF employees.
Right, and this is a shift. The claim against them isn't about active misconduct. It's about a massive bureaucratic failure, an omission.
What was the omission?
So the background is that the DCF investigator, Merritt, told Miller the case was unsubstantiated, way back in June of 2024. She promised a written closure notice would be sent.
Okay, so good news for Miller.
Huge news. But that written notice, which is legally required, never came.
For how long?
For over 7 months, not until January of 2025.
And what's the legal impact of that 7-month delay?
It's everything. Miller argues that because there was no official written notice that the case was closed and unfounded, the state court system, including Meghann, could just keep treating her like she was an active child abuser.
So their failure to do their paperwork prolonged the constitutional harm.
Exactly. It allowed the no-contact order to stay in place for half a year after their own investigator had already cleared her.
And does she have any proof that this was a failure?
She does, and it's a big one. The filing notes that the DCF General Counsel later admitted in an email that the failure to send the letter was an unintentional oversight.
That's a huge admission.
It's a massive admission.
Yeah.
It basically confirms the bureaucratic failure happened. So the strategy is to hold these supervisors liable for needlessly prolonging the separation of this family from June 2024 to January 2025.
So tying it all together, what does she ask the judge to do?
She asks the judge to preserve these core claims against Meghann and the Doe supervisors. But she's also realistic.
How so?
She acknowledges that the court might still see weaknesses in some of her other claims, like an ADA claim or conspiracy claim. And instead of fighting tooth and nail on those right now,
She offers a compromise.
a strategic one, she asks that if those claims are dismissed, that it be done without prejudice.
And that means she could try to fix them and file them again later.
Exactly. And she asked for permission to file a second amended complaint to cure any of the technical problems. It's a signal to the judge that says, look, I'm willing to work with you and meet the standards. Just please don't end my entire case right now over a drafting error or a 3-day delay.
The fundamental plea is for a decision on the merits, not on a technicality.
Especially given her status as a self-represented person, her documented disabilities, and just the fundamental importance of the parent-child relationship that's at stake here.
It really is a masterclass in pro se advocacy under extreme pressure.
It is. These filings take constitutional law, they take state law, they blend it with a very personal, emotional story, and they turn that trauma into procedural evidence. It's all designed to survive this exact kind of judicial screening.
And that brings us to the final provocative thought for you to consider. Miller formally requested that the court, as a reasonable accommodation for her disabilities, explicitly take into account the extraordinary stress and ongoing health impacts caused by the prolonged separation from her children when it's deciding whether to forgive her 3-day filing delay.
So here's the question. If the very facts of the lawsuit, this alleged severe constitutional violation, are what's causing the mental and physical stress that leads to a minor administrative mistake, how should our justice system balance that?
Right. How do you weigh the need for strict, efficient procedural rules against the duty to accommodate a litigant whose suffering is so deeply tied to the legal process itself? That tension, that's the real challenge for courts in these kinds of civil rights cases.
Welcome to the debate. Our focus today is on a really contentious set of filings from the United States District Court for the District of Kansas. We're looking at a pro se litigant's motion for an extension of time. Specifically, it's a nunc pro tunc request, which means she wants the court to retroactively say her late filing was on time. And then we have her response to an order to show cause, or an OSC. This material, well, it really captures a deep conflict in federal law. The strict, often unforgiving mandate of procedural deadlines against, the human demand for equitable justice, especially when the litigant is representing herself, which is what we mean by pro se.
And that tension is profound because it asks us to weigh the rule book against reality. The legal system, it gives pro se litigants some latitude, but once they enter complex federal court, they are held to procedural standards. So the central question here is this. When a pro se plaintiff misses a critical deadline by only 3 days and claims that failure is directly tied to documented psychological trauma from the very case before the court, should the system find excusable neglect and allow the case to move forward?
Yet I'm going to argue that the answer must be yes. The facts here overwhelmingly demand that the court grant this extension. We have to analyze this through the established 4-factor test for excusable neglect from the Supreme Court in Pioneer Investment. It balances 4 elements: the reason for the delay, the length of the delay, the danger of prejudice, and the litigant's good faith. In this case, I think all 4 factors align with granting leniency, meaning justice requires that these substantial civil rights claims be heard on their merits.
And I'll be taking the other side. While I respect the pioneer framework, of course, the integrity of the judicial process has to be protected. Procedural compliance is, well, it has to be non-negotiable, even if the result feels harsh. Allowing this specific calendaring error to pass as excusable neglect, even under the pressure of severe trauma, I think it would undermine the necessary certainty of court orders and set a really troubling precedent for docket administration.
All right, so let's apply that pioneer analysis directly to the facts. First, the delay was minimal. 3 days past the December 3rd deadline, and the motion was filed immediately upon realization. That demonstrates good faith right there. Crucially, the reason cited isn't just, generalized stress. It's a calendaring mistake exacerbated by severe, documented anxiety and PTSD, directly linked to the ongoing trauma from prolonged loss of contact with her children since January of 2024. Furthermore, the danger of prejudice factor. It's 0. This OSC was a preliminary screening. No defendants had to respond. No one was harmed by this minimal delay. And finally, and this is highly persuasive on the question of equity, the court previously granted represented defendants an extension for a deadline they missed by more than 2 weeks. Equity demands parity for this 3-day non-willful error.
I see why you emphasize those points, particularly the lack of direct prejudice to the opposing parties. I do. However, I would frame the reason for the delay and the concept of prejudice quite differently. While the personal circumstances are tragic, the plaintiff is managing multiple related matters pro se in both state and federal court. This demonstrates a certain level of engagement, a capacity to navigate a complex system. So the failure to meet a date that was clearly articulated in a court order, well, fundamentally, that is a failure at administrative compliance. Excusing this simple calendaring mistake based on internal stress, however severe, it risks setting an impossible and unsustainable precedent. If we start overriding procedural rules based on the potential emotional harshness of the outcome, the authority of the court is diminished, and that creates a prejudice to the judicial system itself.
That brings up a critical point. The weight we assign to disability and trauma versus strict procedural adherence. The plaintiff is making a very specific factual claim here, that the flare-up of her documented severe anxiety and PTSD, compounded by the physical manifestation of these recurrent staph infections, directly led to the mistake. The trauma is specific. It's the continued loss of contact with her children through successive holidays, and it is the very subject of the suit. The court already acknowledged her condition in previous orders. Granting a 3-day nunc-pro-tunc extension here is the definition of a reasonable accommodation under the circumstances. It addresses a non-willful failure rooted in a documented condition, a condition that is directly aggravated by the subject of the suit. This is precisely the kind of extraordinary circumstance excusable neglect is meant for.
I'm just not convinced that this meets that extraordinary standard required for excusable neglect. The court isn't equipped, nor is it intended, to function as a medical or, a psychological evaluator for every single litigant's stress level relative to minor procedural lapses. We have to maintain a distinction between true overriding trauma, which is absolutely real and tragic, and an exemption from the judicial process. The court has to apply objective standards. If a self-represented litigant pursuing complex claims under Section 1983, which, let's remember, involves challenging state action under the Constitution, if they cannot manage basic docketing, then we have to question whether the system can effectively accommodate that litigation without representation. If a simple calendaring error is excused due to stress, where does the court draw the line? For the next litigant facing financial strain or family illness?
The line is drawn where the prejudice is non-existent and the claims at stake are fundamental. And that brings us directly to the second core point, the potential for just a devastating dismissal on a pure technicality. The plaintiff's response to the order to show call details serious constitutional and state law claims, due process, First Amendment retaliation, fraud. These claims allege that the guardian ad litem, Randy McCullough, sought ex parte removal while actively withholding exculpatory findings. This led to a 22-month separation and tremendous emotional and physical harms. Dismissing claims of this magnitude, which involve alleged deprivation of the parent-child relationship, based solely on a 3-day calendaring error, well, that's prioritizing form over substance to a degree that actively frustrates justice.
That is a compelling point regarding the severity of the allegations, I grant you that. But we have to consider the procedural reality of the OSC. The court ordered the plaintiff to show cause why the claim should not be dismissed for failing to state a claim. This triggers the Twombly-Iqbal plausibility standard. The court is tasked with weeding out claims that are merely speculative or conclusory, not just claims that lack emotional weight. So, if the allegations as articulated in the complaint are legally implausible under the standard, then the timing of the response is irrelevant. The outcome is dismissal regardless. We can't allow the potential high stakes to excuse non-compliance with the clear procedural timeline that's required to apply the rules in the first place.
But I disagree fundamentally because the substance was filed. It was filed on December 6th, the same day as the motion for extension. The plaintiff details how Makala's alleged act of withholding specific evidence merits unsubstantiated determination, and the clean drug test to secure the removal order meets the requirement of stating a plausible claim. So by filing the substantive response, she demonstrated that the claims are plausible under Twombly-Iqbal. To then ignore that detailed response and dismiss the case based only on the 72-hour error is effectively using the technicality as a shield to avoid confronting highly sensitive allegations that implicate the integrity of the state actors involved. The law demands adherence to the rules, yes, but only to serve justice, not to prevent a case from even proceeding to the merits.
But the rule must be applied consistently. If the court grants the extension, it must do so by finding genuine, excusable neglect, not because the claims are sensational or serious. The plaintiff is asking the court to overlook a lapse based on the gravity of the potential outcome, which is a very unstable basis for judicial administration.
Well, if we're focusing on consistency, let's talk about judicial consistency, which I think is my strongest argument for equity here. The plaintiff specifically requested the same leniency the court has already provided in this very case. I mean, look at the docket again. The represented defendants had a June 20th, 2025 deadline. They filed their extension motion on July 8th, over 2 weeks late, and the court granted that motion. How can the court justify granting an extension for a delay of 17 days to represented professional defendants, yet potentially penalize an indigent pro se litigant by dismissing her entire case for a 3-day non-willful error rooted in trauma? That is the definition of unequal application of equity.
I acknowledge the prior extension granted to the defendants, but we have to clarify the procedural differences to understand why that instance doesn't bind the court now. The defendant's motion related to filing an answer or a responsive pleading under Rule 12a. The plaintiff's current situation involves a response to an order to show clause issued during a mandatory preliminary screening under 1915a. An OSC is part of the court's managerial duty to vet the plausibility of claims before they are even served. Furthermore, the court has wide discretion in managing its own docket. A past example of leniency is not binding precedent that compels the court to disregard deadlines in every subsequent instance, regardless of the procedural context.
The procedural context is secondary to the prejudice analysis under Pioneer. You note the defendant's delay was under Rule 12. Their 2-week-plus delay directly impacted the plaintiff's timeline, her ability to proceed with discovery. Yet the court found that excusable. Our situation is a 3-day delay that impacts no one's ability to move forward, save the plaintiff's own. When the court demonstrates substantial tolerance for represented parties' administrative oversights, even those causing longer, potentially prejudicial delays, equity demands that an indigent, self-represented litigant whose failure is rooted in trauma directly related to the litigation be granted similar grace. To deny her extension based on the technical difference between an answer and an OSC response, while ignoring the massive difference in the length of the delay and the litigant's status, it just undermines the court's appearance of impartial justice.
Fairness, however, is not simply a comparison of outcomes. It's the consistent application of rules. The court's obligation here is to the integrity of the process. If the court establishes a fluid standard for excusable neglect dependent on a litigant's specific emotional or health status, or based on comparative claims of prior leniency, it renders deadlines arbitrary. The plaintiff has to meet the standard on the facts of her specific failure relative to this deadline, not simply by relying on the argument that you were nice to them, so you must be nice to me.
I maintain that when we review the pioneering factors, minimal delay, specific documented cause, and zero prejudice, the only possible conclusion is that the plaintiff demonstrated excusable neglect under Rule 6b, 1b. The failure here is rooted in psychological and physical stress directly tied to the subject matter of the suit, which is the loss of her children. To terminate this complex civil rights case over 72 hours is to sacrifice justice on the altar of administrative efficiency.
And I maintain that the need for certainty and predictable adherence to deadlines outweighs the individual appeal for clemency based on what is, fundamentally, an internal administrative error. If the underlying difficulties mean the litigant cannot consistently meet the procedural standards required for federal court, then the integrity of the system must prevail. The complexity of the claims does not grant an exemption from the rules governing those claims.
So my conclusion remains straightforward. The core principle of deciding cases on their merits, coupled with the minimal 3-day delay and the complete lack of prejudice to any other party, it just compels the court to grant the nunc-pro-tunc extension. Dismissal would prioritize a minor technicality above the pursuit of justice regarding significant constitutional and state law claims. This is a moment for the court to show that its procedural rules are tools for achieving justice, not barriers to it.
And although dismissal would be a severe outcome for the plaintiff, I agree. The necessity of maintaining procedural integrity in federal court remains paramount. The court has a duty to maintain an efficient docket, and excusing a clear calendaring mistake based on generalized, though intense, stress undermines the certainty and fundamental fairness that fixed deadlines provide to every participant in the system.
This exchange really does highlight the profound challenge federal courts face when balancing the imperative of judicial efficiency with the very human consequences embedded in pro se litigation, especially when fundamental rights like the parent-child relationship are at stake.
It is the ultimate test of whether the rule of law can be both predictable and just. The material certainly gives us much to consider as the court ultimately resolves this critical motion.